Counselor, you may proceed.
Now, if I refer to you as Your Honor, it's habit, and I doubt you will protest.
They have you trained, and I don't object, but I'm one of us. So you go ahead.
So I will simply make the point, Your Honor, or Mr. Abbott, thank you. We're here today, in a sense, because of two things. I want to make sure we contrast those two things. The moral controversy over abortion has been one of the great moral controversies of the 20th century. It's a controversy with us today in the 21st century. That is not, however, what's before the Supreme Court today. What's before the Supreme Court today is something that is legally not controversial under current and long-standing case law. And that is the question of whether a state, consistent with the U.S. Constitution, may create an outright ban on abortion. In this case, whether it may do so within its very state constitution. By the plain language of what this initiative petition seeks, it is to do just that. Unlike, for instance, the so-called personhood measure that was at issue when this court made its decision in re initiative petition number 395, state question number 761, back in the year 2012, unlike that measure, there is no nuance here. There is no question about what this measure does. I don't believe there to be any dispute amongst the parties here today about that. The measure is here to ban abortion in all circumstances. Now, the problem is, from that point of view, under existing United States Supreme Court case law interpreting the federal Constitution, that is inconsistent with the 14th Amendment. It has been held inconsistent in cases beginning, of course, with the seminal Roe v. Wade, but perhaps, I think most on point, Planned Parenthood v. Casey, decided in 1992. Now, here in Oklahoma, we have a process of amending our state constitution that is in some ways very permissive. I don't have to be a legislator to do it. I don't have to be in office to do it. Any citizen can initiate that process, including Mr. Hunter. But there is a limit on what can go on that ballot. As this state Supreme Court has recognized, you cannot amend that constitution. You cannot then place on the ballot a measure to amend that constitution that is repugnant to the United States Constitution. That is precisely why, in cases such as in re-initiative petition in 2012, this court has made clear that a measure that bans abortion cannot go on the ballot. Again, this is not the great moral question of whether abortion should be banned. It's really a question of law. It is a question of what is an appropriate means to do so. And in this case, attempting to amend the state constitution to solve what a proponent sees as a problem in the interpretation of the federal constitution is neither the correct way to do it, nor is it legally permissible. This court's precedent makes very clear on that point in the authority I've just cited. Now, this is something we could go more in depth to, but at the end of the day, I'd be redundant. This court's precedent in re-initiative petition is abundantly clear. It is a per curiam opinion. It is a case that has considered these exact issues, both procedurally and substantively, with one difference, but a difference that goes the way of the protest here, and that is there is no nuance. When we were talking about the personhood initiative in 2012, we were talking about an initiative over which it was arguable as to whether it violated Planned Parenthood v. Casey. In other words, it did not necessarily do so on its plain language, though the court ultimately found that it did. We believe it did. We were part of that protest. But the point is, it tried to do so through different language. This is not that case at all. This does so by its plain language. It does so plainly that we do not believe there is any factual dispute here. Now, obviously, if there is factual dispute that the proponent, Mr. Hunter, wants to bring up, we'll respond to that, we'll deal with it. But at the end of the day, the dispute here really seems to be about whether Planned Parenthood v. Casey, interpreting the United States Constitution, effectively bars this measure. This court's case law very clearly says that it does. I believe that proponent of the petition is going to come up and say, I have a different view. I view this differently. I believe that it's a different matter in terms of how we interpret the U.S. Constitution. But this court has spoken and spoken clearly, and it's spoken clearly multiple times. Again, what happens here today and what ultimately happens before this court does not address that larger question. What it addresses is this ballot initiative a legally permissible way to achieve what the proponent seeks to achieve? And Oklahoma law, the Oklahoma Constitution, makes clear that it is not. And I'm happy to take questions or to yield and later respond to proponent. It's of course up to you, sir.
I have no questions. Thank you.
Thank you.
Your name is Thomas Hunter?
Thomas Hunter.
How do you do?
How do you do? Happy to be here. The purpose of these proceedings is to determine the legal sufficiency of State Question 782. I'm not here to argue the great moral question of whether or not mothers and fathers should be able to murder their children in the womb. I agree with the Supreme Court Justice that recently passed, Antonin Scalia, who said that that question is to be determined by the people in the state seeking to persuade one another and then voting, as he said in his dissenting opinion in Casey v. Planned Parenthood. But the purpose is to determine the legal sufficiency of State Question 782. And in particular, the protestants object to the sufficiency of this initiative petition, at least in the paperwork they filed, on the grounds that it is unconstitutional. But as we just heard, the ACLU has stated that it is the precedence of this court that rules that our initiative is unconstitutional. He says the court has spoken over and over and over and over again that it is the legal precedence of earlier rulings, not the constitutionality of the measure, which is at case. So in response, I would submit that the effect of this measure is not only consistent with the United States Constitution, but is demanded by it. For the 14th Amendment states that no person nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Likewise, the Fifth Amendment states that no person shall be deprived of life, liberty, or property without due process of law. The practice of human abortion deprives an innocent person of life without due process of law. Furthermore, by allowing the killing of innocent human beings to go unpunished, the state is denying the equal protection of the laws to those so killed. On these grounds, the current laws of the state of Oklahoma that allow innocent preborn human beings to be deprived of life without due process of law and allow those who kill them to go unpunished are themselves unconstitutional. This petition initiative seeks to rectify this situation, establish the equal protection of the laws for the most innocent and vulnerable human beings within our state, and so bring the laws of the state of Oklahoma into compliance with the supreme law of the land. As it is written in Article 6, Paragraph 2 of the United States Constitution, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, of which shall be made, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Now one might object that the word person in the Constitution, particularly the 14th Amendment, does not include preborn human beings. However, there's absolutely no reason to believe that the writers or ratifiers of the 14th Amendment drew any distinction between the word person and human. John A. Bingham, the principal framer of the 14th Amendment, used the terms interchangeably. Bingham reasoned that all human beings were entitled to the protection of American law because its divine spirit of equality declares that all men are created equal. It is also clear from history that the medical establishment, as well as the judiciary and legislative branch of our government, viewed and treated unborn children, the term generally used to refer to human beings living in the womb at the time, as valuable human beings living and developing under the protection of the state. The 14th Amendment, drafted in 1866 and adopted in 1868, was proposed during a period when our nation's states passed more anti-abortion laws than at any other time in history. The passage of the 14th Amendment thus occurs during the period known to historians of the abortion debate as the Physicians' Crusade against abortion. was throughout this period that members of the American medical establishment consistently called for legislative action to be taken against abortion, consistently referring to abortion as a crime. Leading obstetricians writing for the American Medical Association frequently beseeched their governing authorities to pass legislation to protect unborn children from quack physicians who practice an unwarrantable destruction of human life and, quote, foul, unprovoked murder of abortion. It was the writing of these medical professionals which prompted many of the congressmen who voted for the 14th Amendment to create and enact laws seeking the criminalization of abortion in their state legislatures. And they did not view their prohibitions of killing unborn children to be violations of the constitutional amendment they ratified. The Protestants claim that our measure bans abortion in direct violation of the United States Constitution. I'm sorry, I have read the United States Constitution, and I see no place where it grants the right of mothers and fathers to murder their children. The right to kill one's own preborn children is in no way, shape, or form established by the text of the Constitution itself. Rather, this purported right owes its existence to the written opinion of 7 unelected officials in Roe v. Wade, a decision that is legally, intellectually, and morally bankrupt. I submit that the Protestants might have something approaching a substantial argument if Roe v. Wade actually made a coherent argument from the text of the Constitution itself. However, it clearly does not. In the words of legal scholar Michael Stokes Paulson, the results in Roe v. Wade was to put the matter simply and directly, not warranted by any plausible argument from constitutional text, structure, or history. I begin with the obvious. Roe is utterly indefensible as a matter of constitutional text. The suggestion that the Due Process Clause of the 14th Amendment, no state shall deprive any person of life, liberty, or property without due process of law, actually entails an affirmative right to abortion, immune from government restriction, is hard to take seriously as a matter of constitutional language or of the original understanding of the drafters or ratifiers. In fact, I know of no serious scholar, judge, or lawyer who attempts to defend Roe's analysis on textual or historical grounds. A first-year law student who argued for such a position would likely get a C- in any good constitutional law course, of course, and that's only because of grade inflation. Planned Parenthood versus Casey does not add any constitutional muster to the Protestants' position by establishing the rather questionable position that our nation's commitment to the rule of law is better maintained by refusing to overrule itself when it is or could be wrong, and the Supreme Court has been wrong, as opposed to making decisions that comport with the supreme law of the land as it is actually written. One shudders to think what the Supreme Court means by the phrase rule of law, when such rule of law would be better served in principle by preserving immoral and unconstitutional decisions such as Dred Scott v. Sanford and Korematsu v. United States than by overturning them in compliance with the supreme law of the land. As such, if by United States Constitution we mean the actual written Constitution that has been ratified by the states and approved by the people, then not only is there no constitutional support for legal abortion, but there is plenty of constitutional opposition against it. If, however, by United States Constitution we mean the constitutional opinions of unelected officials, then I would fully agree that this measure is repugnant to that Constitution. However, if we, as a nation, do not bother to obey the supreme law of the land, as it is written, then one is left to wonder why we even bother to write down any laws at all. Now, one might object that stare decisis mandates that the Oklahoma Supreme Court must follow its prior rulings and strike down this measure. However, as even the U.S. Supreme Court itself has reminded us in Agostini v. Felton, stare decisis is, quote, not an inexorable command, but a, quote, policy judgment. Surely it stands to plain reason that judicial policy must submit to the supreme law of the land as it is written, and be overruled in cases of conflict such as this. And surely this is even more the case given that thousands of innocent human beings are killed in our state every year. Lastly, one might object that the Oklahoma Supreme Court is duty-bound to follow the United States Supreme Court rulings in this matter. However, according to the written U.S. Constitution, this is not the case. As legal scholar Michael Stokes-Paulson notes, the courts possess the judicial power of the United States, and that power extends to cases in law and equity arising under this Constitution. But nothing in the logic or language of such a statement of constitutionally authorized judicial jurisdiction implies judicial supremacy over the other branches of the government. Jurisdiction to decide cases does not entail special guardianship over the Constitution. As such, I submit that the Oklahoma Supreme Court is bound by neither law nor oath to follow Supreme Court precedent when such precedent is repugnant to the Constitution of the United States. And as such is clearly the case where this measure is concerned. Because of the 5th and 14th Amendment, I submit that the Oklahoma Supreme Court is not bound by Supreme Court precedent and is free to make its own independent ruling concerning the constitutionality and legal sufficiency of this measure. Former Supreme Court Chief Justice John Marshall once commented on related issues in Marbury versus Madison. His original argument concerns instances where a court must decide on a case where the Constitution is in conflict with a legislative act. But his argument applies equally well to instances where a court must decide on a case where the Constitution is in conflict with a prior judicial decision, or many over and over statements. To paraphrase and apply his argument, John Marshall's, to this particular situation, the relevant portion of his opinion would be read as follows. The powers of the Supreme Court are defined and limited, and that those limits may not be mistaken or forgotten, the Constitution is written. To what purpose are powers limited, and to what purpose is that limitation committed to writing, if these limits may, at any time, be passed by those intended to be restrained? The distinction between a government with limited and unlimited powers is abolished if those limits do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. It is a proposition too plain to be contested that either the Constitution controls any judicial decision repugnant to it, or that the Supreme Court may alter the Constitution by an ordinary act. Between these alternatives, there is no middle ground. The Constitution is either a superior paramount law unchangeable by ordinary means, or it is on a level with ordinary judicial decisions, and like other decisions can be overruled when a court shall please to overrule it. If the former part of the alternatives be true, then a judicial decision contrary to the Constitution does not carry the force of law. If the latter part be true, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature illimitable. Certainly all those who framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently the theory of every such government must be that a judicial decision repugnant to the Constitution is void, that is, at the very least, that it does not carry any legal force beyond the parties to the case at hand. This theory is inseparably attached to a written Constitution, and consequently should be considered by any court as one of the fundamental principles of our society. It is not, therefore, to be lost sight of in the further consideration of this subject. If a decision of a court repugnant to the Constitution is void, does it, notwithstanding its invalidity, bind other courts and oblige them to give it effect? Or in other words, though it be not law, does it constitute a rule as operative as if it was a law? This would be to overthrow, in fact, what was established in theory, and would seem, at first view, an absurdity too gross to be insisted on. It shall, however, receive a more attentive consideration. It is emphatically the province and duty of the courts to say what the law is. That is, in the case of a written constitution, to faithfully interpret the written text of the law in question. Those who apply the rule to particular cases must, of necessity, expound and interpret that rule. If a written law and a judicial decision conflict with each other, the courts must decide on the operation of each. So if a judicial decision be in opposition to the Constitution, and if both decision and the Constitution apply to a particular case, so that the court must either decide the case conformably to the decision, disregarding the Constitution, or conformably to the Constitution, disregarding the decision, the court must determine which of these conflicting rules governs the case. This is of the very essence of judicial duty. If then the courts are to regard the Constitution, and the Constitution is superior to any ordinary act of any branch of government, then the Constitution, and not such ordinary act, must govern the case to which they both apply. Those then who controvert the principle that the Constitution is to be considered in court as a paramount law are reduced to the necessity of maintaining that courts must close their eyes on the Constitution and see only judicial precedent. This doctrine would subvert the very foundation of all written constitutions. It would declare that an act, which according to the principles and theory of our government is entirely void, is yet, in practice, completely obligatory. It would declare that if the Supreme Court shall do what is expressly forbidden, such act, notwithstanding the express prohibition, is in reality effectual. It would be giving to the Supreme Court a practical and real omnipotence with the same breath which professes to restrict their powers within narrow limits. It is prescribing limits and declaring that those limits may be passed at pleasure. In some cases, such as this very case itself, the Constitution must be looked into by judges. And if they can open it at all, what part of it are they forbidden to read or obey? For example, no person, says the Constitution, shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. Here the language of the Constitution is addressed especially to the courts. It prescribes directly for them a rule of evidence not to be departed from. If the Supreme Court should rule instead that 1 witness or a confession out of court is sufficient for conviction, must the constitutional principle yield to the judicial decision for any other court? From this and other selections which might be made, it is apparent that the framers of the Constitution contemplated that instrument as a rule for the government of courts, as well as of the other branches of the government. Why otherwise does it direct judges, both at the state and federal level, to take an oath to support it, an oath to support the Constitution? This oath certainly applies in an especial manner to their conduct in their official character. How immoral to impose it on them if they were to be used as the instruments and the knowing instruments for violating what they swear to support. The Oklahoma oath of office is in these words: I do solemnly swear or affirm that I will support, obey, and defend the Constitution of the United States and the Constitution of the State of Oklahoma, and that I will not knowingly receive directly or indirectly any money or other valuable thing for the performance or non-performance of any act or duty pertaining to my office, other than compensation allowed by law. I further swear or affirm that I will faithfully discharge my duties as to the best of my ability. Why does a judge solemnly swear to support, obey, and defend the Constitution of the United States if that Constitution forms no rule for his government? If it is closed upon him and it cannot be inspected by him? If such be the real state of things, this is worse than solemn mockery. To prescribe or take this oath becomes equally a crime. As such, I submit that an argument put forward by none less than Chief Justice of the United States Supreme Court applies to this very case, and so applied gives the Supreme Court of the state of Oklahoma both the right and the duty to interpret the United States Constitution independently of Supreme Court precedent in Roe v. Wade and Planned Parenthood versus Casey in determining the legal sufficiency of this initiative petition. Wherefore, I respectfully request that this court find that State Question 782 is not repugnant to the written Constitution of the United States, and as such is sufficient as a matter of law and valid for all purposes.
Thank you very much. No, I have no questions for you. I do want to encourage you again to file that with the court clerk.
Yes, sir. We'll do that.
Because it was a good piece of work.
It's hard to read, hear, and follow.
You're playing baseball in someone else's ball field is what you're doing. Good job. Thank you. And I have no questions, and you may be seated.
Thank you, sir.
Mr. Henderson, you may close.
Rather than do a long argument of Roe v. Wade, Planned Parenthood v. Casey again, I choose not to because it's not what we're here to do today. As I said, there are controversies way beyond this courtroom. Much of what was cited by Mr. Hunter proves exactly the point of the protestants here, and that is that we have a written Constitution, and that Constitution is supreme. Now the question arises, what does that Constitution mean at times? Because I'll state the obvious here clearly. For instance, Ms. Chowning and Mr. Hunter could look at the same federal Constitution, and I don't think it goes on too far of a limb to say they see it impacting the question of reproductive freedom or reproductive justice in different ways. Just as one person can say this is about the right to life of an unborn child, another can say this is about the personhood of a mother who is a person and not an incubator. Those arguments have been blasted out in the U.S. Supreme Court over and over and over. The point is, we don't have 300 million constitutions in the United States. We don't have a personal constitution for every one of us as citizens that matches exactly what we believe. We have a system whereby 9 people, right now 8 people, and hopefully 9 at some point again, make a decision and say, this is what the Constitution means. It is very basic to our system of laws, and it's necessary for the organization of a legal system. I respect very much the quotes, for instance, from Marbury v. Madison that Hunter cited, the very quotes that say this is emphatically the duty of the courts to say what this means. As in fact Mr. Hunter pointed out, if you have a court that does not take up this oath to preserve and defend the Constitution, it is absolutely a sullen mockery. The question here is when we do this. Here's the problem with the idea of simply saying, why don't we allow the petition to be circulated, let's get the signatures, let's see what happens, let's put it on the ballot. The question of whether or not it can become law consistent with the U.S. Constitution does not change. Either way, the same result has to happen legally. So the only thing that does change is, as taxpayers, we foot the bill that entire time for the processing of the initiative petition, the checking of the signatures, going through everything that leads into the ballot itself and the printing of the ballots themselves. What we ultimately generate is the most expensive public opinion poll in state history. What it says at the end isn't really the point. The question is, if we want to have a public opinion poll, if we want to have effectively a public referendum on where do we think people are, what do people think about these issues, the question is, do the taxpayers fund it or do citizens fund it, like any other public opinion poll? That's really all the protestants are here to demonstrate. It's a matter of timing. The result doesn't change. The question is, do we finance that with tax money? Do we take money that is paid by taxpayers and use it for the public opinion poll? There is a petition, in fact, being circulated right now by some of the same folks, I believe, affiliated with Mr. Hunter. The signs are around the area, abolish abortion okay. It's not this petition, but it is effectively a petition that is not an initiative within Oklahoma's law, but it's one to be put to the legislature. It's what we might call an informal petition. That's the way to do it. If we're talking about simply wanting to create a public debate consistent with things like the very idea of the First Amendment, which we at ACLU are very proud to defend, and defend even when it is unpopular, that's how we do it. We do not co-opt taxpayer resources for private speech. We do not co-opt taxpayer resources for a public opinion poll? That's the question. It's a question of timing, a question of procedure, and a question ultimately not of what do we do substantively, but how do we do it? For those who look back at cases like Roe, cases like Planned Parenthood, and say, I do not believe this is what the Constitution says, there is a very clear way to do it. There is a very clear way in which to respond, and that is not to, within a state, try to create something in a state constitution that simply has to get struck down under basic principles of law, but it is to seek to amend the federal constitution or seek to change the U.S. Supreme Court, who is the highest arbiter of what that constitution says, when its interpretation comes into question. Again, that is the fundamental question today. It is a question that has a clear result, and a result that's consistent with law, and a system of law that in fact is very, very well intelligently designed. A system that ensures a fundamental set of rules by which all people play. And sometimes we may be happy with the results, and sometimes we may not. And sometimes those results may change. But that system does not allow us to attempt to short-circuit those results through a procedure that does not work under that system of laws, and thus co-opt the resources of a state simply to try to demonstrate our views. That's the fundamental problem. That's why this protest has been filed when it has, rather than after a signature collection period. And it is why it is important for this court ultimately to make the same decision that it did in 2012. A decision that affirms that there is a system of laws, and everybody, no matter what their views are, even on the most controversial questions, plays by that same set of rules. Thank you.
Thank you.
Yes. The Oklahoma State government actually have in its budget a line allowing pay for initiative petitions.
Does it have that in the budget?
Yeah, we have a budget. We're not siphoning tax dollars.
I would have no idea.
Well, I put it as a question. It's already there. We're not changing anything. The tax dollars are allotted. If you can circulate petitions for marijuana, you can circulate petitions for everything and anything. If you circulate a petition for something that the American Civil Liberties Union doesn't want you to circulate a petition for, they will say that we're wasting tax dollars. That's just their way of keeping us from circulating petitions.
Yeah.
Can you speak up? It's not a bad habit. It's okay.
You guys use the microphone, please. Okay.
My apologies. Better? And first of all, I do not know of any line item in the state budget. What I do know is clearly the state has money that it spends. I mean, the record of this case shows about $1,000 spent on the publication of notice. That is spent whenever a question is filed, once it gets past a couple of basic hurdles at the beginning. We know it costs more to print more on ballots, print longer ballots. Realistically, I don't know. I'm sorry?
We print the ballots.
No, the state prints ballots for elections.
Oh, those ballots.
Yes. I'm not talking, yes. What I'm talking
They're
about
already
is
printing
that,
those ballots.
right.
They're adding a line.
Yeah. Simply that I don't know that there is a way to know beyond that $1,000 what exactly is spent. We don't.
All right.
They spend more money protesting it, do they not? Let us circulate our petition.
I'll put that on my report.
I'm really just talking. I just think it's strange that it would come down to this is going to cost the taxpayers money that they've already paid in their taxes, and there's actually a right to circulate a petition, to file an amendment initiative, and collect signatures in pursuant thereof putting it on the ballot. It's a right. You're saying, no, you shouldn't be able to have that right if it's something that's going to trouble us or cost us money. We're raising $120 million to refurbish the stones over there at the Capitol. I think $1,000 that they choose to spend to publish the notice so you guys can see it and protest us, that was their choice, not mine. It's the process.
Well, gentlemen, see, this is what lawyers do. We're doing it too. I think I got the part of this that I need. Because now I have to go write a report to the court, and then they will see the papers that you file. They will see the papers that you file. If you don't file them, they won't see them. And they will see my report, and you don't get to see my report. So I'm going to write a report about this argument today and tell them all about it, and then they'll decide whatever they decide.